Good morning to all of you. This is for legal ethics students, final year students, question paper 2014. Of course, questions are repeating yesterday. I have answered one paper, almost similar cases are been. Let us quickly have a glance to the questions. Question number 15. The State Bar Council formed rule for no confidence motion against the chairman or BC. The rule was challenged as a small body like BC cannot remove. This yesterday we discussed in detail. So please remember section 15 of the Advocates Act, which says deals with the rules regarding the bar council chairman, vice chairman, include all these things. Yes, in that connection, the bar. So already I told you section 16 of the General Clauses Act says so the recruitment is equal to ousting. So when you elect a person, definitely same section will apply to suspend or dismiss a person also. That case law also we have discussed. Bar Council of Delhi versus Bar Council of India 1974. And second case, Karnataka High Court Magdum also I have given. Please read it. It is very easy for you to answer. Then question number 16. The advocate had withdrawn the decretal amounts and misappropriated without knowledge of the complaint. Yes, definitely. This is equal to question number 15 of question paper 2017. Same question. So, you know, Prahlad Sharan Gupta versus Bar Council of India 1997. Or that Ramakur Koteshwara, I don't remember the case law. Anyway, this is the best case law. So Prahlad Sharan Gupta versus Bar Council of India 1997. So please remember, you may be knowing that whenever you file the wakalat under Article 3, Rule 4, definitely you are representing your client. But as per I think Rule 22, you should not misappropriate the monies of the plaintiff. That means no doubt you may be handed over the money because of the wakalat. Nowadays, I think the people are calling them the complainant, the plaintiff himself or the DHR and handing over the money. But these are the olden days. This incident happened in 1997. You may be knowing. So please remember, according to this is a violation of Rule 27 also, because you should not misappropriate the money. Here he was given an amount of 1600. Actually, how it was given? He colluded with the JDR actually. So he collected the money, but he did not hand over the same to the DHR. DHR was moving around him. Ultimately, when the DHR questioned him as to why he is not handing over the money, he said simply, "Arey Baba, that was deposited in the court." Simply, he deposited the money in the court, right? So then what he has done? For getting back the money, he has collected once again 450 rupees. Is it not misappropriation? See how litigantly this advocate has done. So clear, he was suspended from practice for 1 year. Please remember. Another case. So Atmaram Nanak Chand, you may be knowing, versus Sri Ram Contractor Ghaziabad. Same case, P.S. Gupta. Actually, P.S. Gupta versus that Ramurthy case. So likewise, so many cases are there, but anyway, if you say one or two cases, it's sufficient, you know. Then question number 17. Bar Council of India framed pre-enrollment training. So already yesterday we discussed, which is violative of Article 19(1)(g). Discussed. Definitely, please remember, all of you know that previously there were rules. There were rules that the advocate has to undergo practical training for 1 year, 3 years, like that. But when this matter has come before the court clearly stated that in the case of V. Sudhir versus Bar Council of India, so who filed a writ petition? Because, please remember, Bar Council of India can frame rules regarding the legal education also. But please remember, the advocate and the Advocates Act comes into force when he is enrolled an advocate. Before that, why are you compelling him to undergo training? So this is absurd. Actually, Supreme Court agreed with the proposition. Why? Because suppose if the persons are given practical training, definitely it will be helpful. They will become very good lawyers. But that is not mandatory. He will learn by virtue of his experience, is it not? So therefore, this V. Sudhir versus Bar Council of India 1999. Training need not be restricted to attending chamber, but also to the court under the supervision of the court staff. But it is being done while in the college, because they are going to conduct the moot court program, they are conducting a seminar, they are conducting the literacy camps, all things. So thus training not necessary. Finish. So therefore pre-training is not necessary. Yesterday we discussed at length. Then question number 18. BCI framed rules prohibiting person more than 45 years not eligible for enrollment. Rishabh Duggal case, you know. So yesterday also same. I think these questions are totally repetition of the same. I did not. I think you are waste your time also, because Rishabh Duggal case is a very clear case where it is violated of Article 14 and also 19(1)(g). Because people who are interested, they can study, they can learn at any age. Age should not be a restriction for them. So therefore, Supreme Court suspended the orders of the Bar Council of India. So any person of any age can study law. This is Rishabh Duggal case versus Bar Council of India, right? So if you mention these case laws, it is sufficient. I think the questions are repeating. I need not explain in detail, right? Thank you very much.